So, for the introduction, an offender who commits a criminal act without the presence of positive intent or what we call mens rea can use intoxication as a defense. Nevertheless, intoxication can result in a complete acquittal or qualified acquittal according on how the court determined on the fulfillment of the elements of the provision. The India Penal Code provision on intoxication were part of the law until 1935, then they were replaced by the current provision. According to the drafting of provision in Indian Penal Code 1837, Macaulay said that the accused do not have to be so intoxicated as not intend or know that the act was wrong. The defense succeed as long as the intoxication caused a loosening of the accused's inhibition, leading them to do criminal act that they would not do if sober. This opinion has been modified by the framers of the Indian Penal Code, which they narrow the scope where the accused can use intoxication as a defense. In Section 85, it stated that at the time of the offender commits the crime, he or she was incapable of knowing what they are doing is wrong or contrary to law, even if he was intoxicated without his knowledge or consent. The provision allows involuntary intoxication to be a defense with certain conditions. Malaysian Penal Code was following the provision of Indian Penal Code until an amendment was made at 1935. The amendment sought to codify the English common law as pronounced by the House of Lords in the case of DPP against Bird. As you can see in the slide here, this is the ruling made by Lord Birkenhead. English law recognizes intoxication as drunkenness. Only Section 85, Clause 2b included the first ruling of the Lord where the person charged was by reason of intoxication, temporarily insane, whether produced by drunkenness or else at the time of the alleged crime. However, two more rulings were not adopted in the provision. Next, I will give you a simple overview on what is the meaning of general defense. To be easily understand, the word defense refers to those claims that the accused can use if he commits an offense but want to seek exception to escape from the liability imposed on him. There are some categories of defenses in Malaysian Penal Code and two of them is specific defense and general defense. General defense cover a wider range of offense when the accused can use any exception under this part which they find is reasonable. Vice versa, specific defense can only be pleaded concerning the specific crime. Specific defense cannot be applied to all crime as it has specific and strict element needed to be fulfilled. This project will discuss more on the topic of intoxication, which falls under the term of general defense.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. And I hope everyone are in a good situation, especially during this pandemic. My name is Muhammad Azhar Faiz, metric number 061172. And as for today, for the subject of criminal law, I will be present on the defense of intoxications. So as for the introduction, in criminal law, it is essential to prove the actus reus and mens rea, and if a person who does a criminal act in a state of intoxication, it is going to be a good defense to enable that person to be acquitted for the offense charged in some circumstances. For instance, when a person who act criminal crime, it cannot be held guilty if the act was done when he is under the intoxicated state and the state of intoxication were caused without his consent. However, if a person commits a crime and in a state of intoxication and on its own desire, that person will be held guilty for his act. If we look under the Penal Code Act 574, the defense of intoxication is complete defense, which not really a mitigating factor, and also the scope of the defense is limited in its application. Thus, Section 85 and Section 86 of the Penal Code, it stipulated that the defense of intoxication shall be a defense to any criminal charge if, number one, at the time of the act, he was in a state of intoxication. Number two, he did not know that such act was wrong. Number three, the state of intoxication was caused without his consent. 4, the person was charged due to the reason of intoxication insane, either by temporarily or even otherwise at the time of the act. And 4th, the purpose of determining whether the person had any intention. And as for this, if we look at the case of AG for Northern Ireland against Gallagher, Lord Denning stated that if an individual has an intention to commit a crime and he intoxicates himself, the mens rea is not diminished. Now, we're going to move to the element of intoxication under the Penal Code Act 574. And as usual for the introduction, Penal Code Act 574 is a piece of legislation which concern on each and every criminal offence in Malaysia together with the substantive laws. The reason I'm telling you this is for the general knowledge. And furthermore, the origin of the penal code itself is based on the Penal Code of India 1860, and under the statute, it also concern on the matter of intoxication, which can be seen under the section 85 and 86. So first of all, we're going to look under the section 85. From the statute, which is under especially on the section 85, it cannot be concluded that the self-induced intoxication, it cannot be a defense which based on the Latin maxims, which known as the Q picet et brus, what sobrius, which defined as who seen drunk it atones a sober. Moreover, this section also touched on the matter of knowledge of an accused person during the time of committing the act. In the case, if you look at the case of public prosecution against Beard, 1920, the defense was charged for murder, a 13-year-old girl by raping, putting his hand upon her mouth and his thumb upon her throat. The defense was drunkenness, and according to the Lord Birkenhead, he stated that the distinction between the defense of insanity is the true sense caused by the excessive drinking, and the defense for intoxication is produced such that the drunken man mind become incapable of forming a specific intention. Moreover, if we look at the case of Burrow and also Rennie, how Justice Holroyd has refused to use this concept of drunkenness as a defense unless it had induced a continuing and lasting condition of insanity. Therefore, a specific intention is an essential element in this offense. Thus, intoxication is a defense to a person of a sound mind, although has the ability to form the intention and did not form such intent at the time of doing the act. Furthermore, a person who acted violently in a state of intoxication does not come with Section 85 Clause 2 if he did not know or volunteer to be intoxicated, and in the event where the doctor gave drugs prescribed also cannot avail himself to the protection of the section under the Section 85 Clause 2A unless it can be proven that it's a negligence caused by the doctor. In other words, this section covers all instances of involuntary intoxications. Moving on to section 86 of the Penal Code Act 574, and if we look in the case of public prosecutor against Kenneth Fook Moon Lee in the year of 2003, Justice Augustine Paul stated that by virtue of section 85(2)(a) of the Penal Code, intoxication is a defense to any criminal charge when the accused did not know what he is doing and the intoxication are caused without his own consent. By virtue of the section 86 clause 2 of the Penal Code, it provides that when the accused is intoxicated, either by voluntary or otherwise, it will be taken into an account whether if there is any intention exists there. Moreover, if we look at the case of the Director of Public Prosecution against Majewski, 1977, the House of Lords held that the self-induced intoxication negating mens rea is a defense. Thus, Section 86(2) will not apply in the case of offence requiring mental elements. Therefore, virtue of knowledge are the ingredients which the intoxicated person had the same knowledge as he would have if he had not intoxicated.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Ainatul Nadia binti Zainuddin. My metric number is 060086, and for my part, I'm going to share with you on application of the defense of intoxication in Malaysian cases. Public Prosecutor versus Stephen Lagan in 2019. The accused was drinking and went home. After he could not find the deceased, who was his wife, in the house, he asked his son to go and tell the deceased to come home. The deceased was actually went over to her auntie's house. The deceased told her son that she will get home. When the deceased arrived at home, the accused was mad and they were involved in a heated argument. In the argument, the accused clearly said that he will kill the deceased not once but twice. Both of them went into the kitchen. The accused, who could not control his anger, then took a parang and slashed the deceased's neck. The deceased died instantly in the kitchen. In his defense, he told the court that the deceased was the one who actually took the parang first and attacked him. While they were struggling, he accidentally slashed her neck. The defense also raised intoxication as another defense since he was drinking earlier. The accused was charged with murder under Section 302 of Penal Code. For the decision, the court held that the accused was found guilty as charged and convict him accordingly. The accused is sentenced to death by hanging to the neck until death. Application. The accused was self-intoxication, which under general principle, he cannot raise a defense of intoxication. There is an exception under Section 85, subsection 2, subsection A and subsection B, but since he voluntarily consumed the alcohol and was totally aware of what had happened during the incident, which indicates that he does not temporarily insane and he does not fulfill the element. Therefore, his defense of intoxication was failed. In other cases, Lee Tiam Wat versus Public Prosecutor 2019. The accused was a 49 years old and works as a security guard. He stated that at the age of 25 years old, he started to get involved with the drug methamphetamine and was also an alcoholic. Due to this habit, he was admitted to the University of Malaya Medical Center in 2003 and at the Sungai Buloh Hospital in 2009, but didn't go through follow-up treatment. On 21st of March 2013, the accused visited the deceased, who was his sister, at her home and spent a night there. At night, he confessed that he was taking cannabis drug. The next day, he went to a temple and met with the deceased. Suddenly, he took a sword and slashed at the deceased's hand and leg before stabbing her multiple times due to his hallucinating that his sister had turned into a tiger. After the postmortem, the death was due to the multiple slash wound to the face and neck. The court found him guilty of murder under Section 302. He then made an appeal to the High Court. The decision, the High Court allowed the appeal. The accused was released from the charge and was ordered to be admitted to Bahagia Tanjung Rambutan Hospital as long as he can get forgiven from the Sultan Selangor, just like under Section 348 of Criminal Procedure Code. An application. Due to his drug abuse for a long time, the side effects such as having a hallucination were established by medical expertise. He can be considered temporarily insane during the incident, which makes him cannot differentiate between his hallucination and reality. He did not know what he was doing and mistakenly believed that he was killing a tiger and not his sister. His situation fits perfectly under Section 85, subsection 2, subsection B, by fulfilling all the elements. Hence, his intoxication defense was successful.
Assalamualaikum warahmatullahi wabarakatuh. I thank my fellow groupmates for presenting their respective parts, and now I, Khairumune bin Mayadi, will be discussing on this application of the defense of intoxication, specifically how England applies this defense and how it relates to Malaysia. Generally, we can see that this defense is not applicable for those who self-intoxicate. This is because people should be held accountable to their own actions. This is also the stance taken in England, but the courts have taken to give exception to this rule, as we can see in the case of DPP against Majewski. In this case, the court held that self-intoxication was not able to be raised as a defense because the accused was charged with a crime of basic intent. Lord Diplock, in R against Caldwell, explained this principle by stating that when a crime only needs recklessness as its prerequisite for mens rea, it is a basic intent crime. This rule is further expanded upon by subsequent cases to give the defense of intoxication for self-intoxication in even narrower circumstances. For instance, in cases where ingesting a substance not generally known to cause intoxication would be applicable to the defense of self-intoxication. In R against Bailey, the diabetic assailant was induced into a state of automatism whereby he was not able to control his actions because he went into a hypoglycemic attack after drinking a mixture of sugar and water. The Court of Appeal found that it was not commonly known that hypoglycemia would induce such a state of incapacity to the point that the patient would not be able to control themselves. Thus, in such situations, even though the ingestion was voluntary, the state of intoxication itself was not intended. In conclusion, we can see that the defense of intoxication generally gives excuse to those who are unfairly put in a disadvantageous situation out of his control. Normally, self-intoxication would disqualify people from applying this defense, but in certain situations, this can apply. Thank you for listening to our presentation and have a good day.